We were in here earlier, so. I was on that. But it's time.
All right, we're good to go. Hey, Patrick.
Great. Yeah, thanks everyone. Busy time of year right now, so apologies for the delay on jumping on. The summer's flying by. Welcome everybody to our August Mine Land Reclamation Board meeting. It's going to be a hybrid meeting, and I'll go ahead and start with roll call of the board. Ms. Wareham. Not here. Okay. Ms. Nelson.
Present.
Mr. Singletary.
Here.
Mr. Edmond.
Present.
And Mr. Mock.
Present.
Great. Thanks, everyone. We have a quorum. Has everyone had a chance to look at the July 2023 minutes? We're good there. Okay, could I get a motion to approve?
So moved, Tim Mock.
And can I get a second?
Second, Nelson.
All right. All those in favor, say aye.
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 Those opposed? Motion passes. Thank you, everybody. And I don't think we have any continuances or withdrawals this time, it looks like. So that leads us to jumping into the Executive Director's Office and Division Director reports. Go ahead, Mr. Mock, whenever you're ready.
Great. Thank you, Mr. Chair. Good morning, members of the board, Director Brandon, Tim Mock, Deputy Director with the Department of Natural Resources. A handful of updates this morning. One, our new Assistant Director for Parks, Wildlife, and Lands, Tim Brass, has started working for the Executive Director's Office. Tim Brass is joining us from Backcountry Hunters and Anglers, and previously was a Forest Service ecologist and land use planner with the local municipality. So we're excited to have him on board. We will be hiring shortly for a federal affairs position. This is an individual that manages largely the agency's response processes to federal comment documents, NEPA planning and such. Hope to have that posted in the next couple of weeks. State Land Board, in other news here, approved an exploration lease for a geologic carbon sequestration project on a 5-0 vote last week. The exploration lease will allow EOS sequestration to do work to characterize the site. A separate injection lease would require State Land Board approval before any CO2 has been injected. We've got several boards and commissions meeting this week. In addition to us, that would include the Geographic Naming Advisory Board and the Groundwater Commission. Next week, we have Colorado Parks and Wildlife Commission up in Steamboat in will be occurring during the same time as Water Congress. So there'll be folks back and forth between both of those. Naming Advisory Board, we do expect now that the U.S. Board of Geographic Names will take up consideration of renaming Mount Evans at its next meeting on September 15th. The Department of Interior has apparently concluded its consultation with the tribes and will move forward with consideration of that matter. The CWCD sent out a press release yesterday. The state of Colorado provided official comments to the Department of Interior regarding future Lake Powell and Lake Mead operating guidelines as part of the process to develop the post-2026 guidelines for the operations of Lake Powell and Mead. The post-2026 operational guidelines will replace the 2007 guidelines that will determine how the two reservoirs are operated into the future. The 2007 guidelines have proven insufficient to sustainably manage both reservoirs in the face of prolonged drought due to climate change and ongoing lower basin overuse. The Colorado Water Commissioner, Becky Mitchell, was joined by the CWCD Board Director, Lauren Riss, in developing and signing Colorado's comment letter, which is located on their website, on CWCD's website. Additionally, Commissioner Mitchell co-authored a comment letter with fellow upper division states through the Upper Colorado River Commission, as well as the comment letter with the 7 basin states. And then finally, CWCD is expected to appoint its new director at its upcoming meeting. And that concludes my report.
Thank you, Mr. Mock.
Can anybody hear me?
Yeah, any questions for him? Yeah, go ahead, John.
Hey, Tim, do you know how they ruled out what the Colorado Water Conservation Board did on the Chico Basin Ranch their last meeting? What they did on that lease there?
Yeah, Mr. Singletary, I think you mean the State Land Board. They had a conversation with the board. Staff will be deciding the outcome of the lease there at its next upcoming meeting. So no decisions were made at the previous State Land Board meeting. I'll keep you apprised.
Okay, thank you.
Thank you.
All right, any more questions for Mr. Mock? We're good, okay. Ms. Brannon, for Division Director report.
Yes, good morning, everybody. Judy Brannon, Division Director. Yeah, just one thing, everybody's, with wildfires and everything, certainly Maui and in Colorado as well. It's on everybody's mind, and it's on our mind first and foremost. And we are wanting to use the majority of our 10 million, which we're now going to get for 15 years from the infrastructure bill, which is fantastic, for these abandoned mines that have underground fires, these old coal mines that have underground fires, because they interact with the wildfires and they egg them on and they egg each other on. And it's happened more than once. And so our first focus right now is the Lewis fire. That's very near the Marshall fire. And Marshall got much more attention because it was responsible for burning down all those houses. Because it was kind of south and then went west. Lewis was further north and then went east. So Lewis didn't destroy as much, but right now it's a much bigger danger. The surface temps are way too high. It's not high enough right now to set vegetation on fire, but a little bit more and it will be. And you get a wind that kicks up, and it's windy out there. So we just really need to get on that. And that's going to be our focus. We're going to excavate, we're going to cool the coals down, and then we're going to refill and regrade. So it'll be quite the project. Marshall will follow immediately after that. It's certainly on our map, but Lewis is the more immediate threat right now. So that's what's going on with IMP, and that's not all that's going on with IMP. We're headed into the rest of this construction season, and then coming into next year's construction season, really busy season. Probably as busy as they've ever been. That's all I've got.
Great, thank you, Ms. Brannon. And any questions for the division director at this point? All right, moving right along. Item number 5, an enforcement hearing for file number M-2003-002 for High Country Repair. And it's dealing with the Ghost River gravel pit. Looks like we have Amber gonna present on this?
Yes, hi. Can you hear me? Can you see me?
Sorry to interrupt, Patrick. Do you want to swear everyone in?
Oh, yeah. Everyone that's providing testimony in this, please raise your right hand. You promise to tell the truth?
Yes.
Great, thank you. Thanks, Chuck. All right, go ahead, Amber, whenever you're ready.
All right. Good morning, everyone. My name is Amber Michaels, and I'll be representing the division in this matter. I'll be reading from the presentation form that I supplied to Cami. So if anyone doesn't have it, just let me know and I can put it on the screen. This enforcement hearing is for the Ghost River gravel site. The permit number is M-2003-002. It's permitted as a 110 limited material or limited impact construction materials permit for 9.9 acres. The mining commodities at the site are sand and gravel, and the operator is HCR High Country Repair. This site is located in Huerfano County, and the existing bond is $19,112, which the division has determined is not adequate at this time. The board should be aware of this site. There's been a long history and chronology prior to the last time that it was brought before the board in December of last year. But if not, I can jump back and go through its history. Otherwise, I'll just go ahead and go to the basis for permit revocation and final forfeiture of the financial warranty. So in the board order from the December 14th, 2022 MLRB enforcement hearing, the board found the financial warranty for permit M-2003-002 to be subject to forfeiture under the statute for the operator's failure to cure a default under its performance warranty. Also, the board found the operator in violation of the statute for failure to comply with the board's October 22nd, 2021 order and suspended permit number M-2003-002. Pursuant to the statute, upon determination after a hearing that a violation of a permit provision has occurred, the board may suspend, modify, or revoke such permit. The operator has failed to cure the default of the performance warranty and is still in violation of the board's order. Therefore, the board may revoke the permit. Pursuant to the statute, when the board has reason to believe a financial warranty is subject to forfeiture, it shall also notify the operator and all financial warrantors. The board shall grant the operator and all financial warrantors the right to appear before the board at a hearing to be held not less than 30 days after the party's receipt of such notice. Pursuant to the statute, at a hearing held pursuant to the statute, the board may withdraw or modify any determination that the financial warranty is subject to forfeiture, settle or compromise the determination, or confirm its determination that the financial warranty should be forfeited. The division mailed the notice of enforcement hearing for forfeiture of financial warranty to the permittee pursuant to the statute. The division holds a cash bond from the permittee for the site, so a separate notice for an additional financial warrantor was not necessary. To date, the permittee has failed to comply with the board's ordered corrective action and has not cured the default of its performance warranty. Therefore, the financial warranty is subject to forfeiture and the permit should be revoked. The division staff recommends that the board should revoke permit M-2003-002 in accordance with CRS 34-32.5-124, parent 6, parent A. Confirm the determination that the financial warranty is forfeited in accordance with CRS 34-32.5-118, parent 3, parent A. Issue an order directing affected financial warrantors to immediately deliver to the board all amounts warranted by applicable financial warranties in accordance with CRS 34-32.5-118, parent 3, parent B, and order the civil penalty of $38,700 due and payable.
All right, thank you for that. And we have the operator here. Do you have any thing to add?
Yes, actually, I guess to clarify for the record and for the board, I am the current personal representative for the estate of Douglas Branch. Douglas Branch was the sole owner and operator of High Country Repair. High Country Repair was the holder of the permit in this matter. Therefore, Mr. Branch would have been the only person to speak to the board. Upon his passing, this matter I know has been extended for quite some time by the board. The action initially began in July of 2021. Mr. Branch passed in September of 2021. And then his spouse, as the representative of the estate, submitted, albeit late, but applications for conversion. The limited liability company should have ceased to exist, that being High Country Repair, at the passing of Mr. Branch. I believe that all notices have been sent to High Country Repair or the representative of Natasha Goldberg as the prior representative of the estate. I have been informed of today's hearing via email from the division. I appear for the following purposes. I believe that there is no financial warrantor on the bond. I believe that it was a cash bond that was posted in the amount of $19,112 as represented by Ms. Michaels to the board. So the forfeiture of the cash bond would be made, but I am not aware of any financial warrantor. I also appear with regard to the suspended civil penalty, which I understand is within the discretion of the board pursuant to statute. I would inform the board that the estate is insolvent, that the funds that the board has received in the amount, I believe, of $4,330 would likely be all of the funds that would be available for payment in any form of civil penalty. So at this point in time, I would just ask the board accept what has been paid, with the understanding that any further collections actions would simply make the division a creditor of the estate, and that process would have to be pursued for any collection. There are numerous creditors, including most significantly the Internal Revenue Service, who are creditors of the estate. So I simply would advise the board of those matters, would advise the board that there is not a conversion application that is currently submitted with appropriate authorization for its submission before this board, given the estate proceeding. And if there are any questions, I am happy to provide any responses the board may need.
Any questions for Ms. Owen? Is that how you say your last name, Owen?
Oyen.
Oyen. Okay, my apologies.
No, that's what they've always told me. I could be wrong.
Yeah, I'm not really sure what to do here, so.
I think we need a little leadership advice from the staff on.
Yeah,
Here.
where some advisement on what are our options here.
This is Jeff Huey with the division representing staff in this matter. Ms. Oyen, I don't know that you and I have actually spoken. I think we've been on a few emails together. I did talk with other folks involved in this matter in the last 6 months or so. At this point, I think I understand that you're not contesting the division's request to revoke the permit and forfeit the bond. Is that correct?
I do not have any objection to that process. I just wanted to clarify and clarify and also affirm that it was a cash bond that is available, so that there are no warrantors, if that's a real word, for the bond. So it would simply be that the division, whatever amount of the cash bond that was posted, would be forfeited to the division.
Yes, that's correct. The bond, 19,112 is all cash. So that's the amount the division would request that the board forfeit. Staff would then utilize that to reclaim the site to the extent they're able to do so. I guess with the confirmation that there's no objection to the revocation forfeiture request, Mr. Chair and the rest of the board, that's what the division is seeking here, is that the board enter an order revoking this permit, forfeiting the bond, which essentially terminates the life of mine at this particular site. With respect to the civil penalties, this is a a fairly unusual situation where we do have I guess the High Country Repair no longer really exists as an entity. Ms. Oyer has testified that, or Oyen has testified that there is no ability to make payment on that civil penalties. I'm not sure, it's up to the board's discretion, and maybe Mr. Quayman, you can advise on if you want to have that unpaid civil penalty amount to remain in a form of collection to allow the state to pursue that, or if the board in its discretion wants to just suspend that penalty amount so it doesn't exist in kind of an uncollected penalty column in the division's forms.
And if I could just add one other thing, in terms of the High Country Repair LLC no longer existing as an entity, it's no longer doing business, but it also has been dissolved with the Secretary of State. So just for formality purposes, I think that's important for the board to understand.
The last point I want to clarify or restate is the board order for High Country Repair to convert this permit into a 112 is you heard today in testimony. There is no pending application. That application was denied in July. Is that right? By the division, they denied it in July. So there is no pending application. There is no intent to continue to work on this permit. So revocation forfeiture makes sense under those circumstances as well.
Mr. Fugate, Jeff, should we, I mean, with the information we have here, do you want us to take a motion that's reflected by staff recommendation? Or since you've heard what we just heard, do you want to maybe remake a motion of statements so that we won't have any legal problems down the road? I mean, are we in a place right now, do we have the information that the staff needs to go ahead and act on this? Or do we need to do something extra to make sure there's not a problem down the road?
I don't think there's any, I mean, there's some unique or unusual facts here, but from a, I guess, board process perspective, this is not too unusual. This is a typical revocation and forfeiture based on non-compliance of the operator. So I guess to restate staff's recommendation, it would be that request that you revoke this permit, confirm that the financial warranty is subject to forfeiture. You move forward with forfeiting the bond, which is a cash bond here. The only thing that's up in the air, maybe for further board deliberation or discussion, and maybe you can hear from Russ, is what to do with the unpaid past due civil penalties, $38,700.
Yeah, because it sounds like the operator stated on our documents, HCR is dissolved. So it's a question of what's liable at this point, right? I mean, am I off base there? Is that kind of what we're trying to decide?
Oh, I mean, there is an obligation here. You know, even with a dissolved company, they still owe this money. It is something that board or staff could pursue in collections, but you know, I think it's a situation of throwing money and resources at something where you're unlikely to receive anything in return. You'll just kind of get in line with other creditors to collect. So Russ,
Thanks, Mr.
Yeah, Mr. Chair, this is Russ Means for the division. Staff doesn't have any objections and stuff with the suspension of any unpaid civil penalties, given the facts and everything. We'd be just throwing good money after some bad. And I believe they did pay some instead of the initial. So in order to close this matter, and that we would recommend and stuff that the board just suspend any outstanding penalties and call it good.
Great, thank you for that, Mr. Means. Or go ahead, sorry.
Jeff, you get here. So just to round out the recommendation, then I guess add on that staff would recommend that the board waive the penalties that are due. So there's no monies past due showing up on any accounting on this permit.
All right. Would any members of the board like to make a motion with those added stipulations?
I can. I move to revoke permit M 23 or 2003-002 in accordance with CRS 34-32.5-124 parent 6 parent A, and to confirm the determination that the financial warranty is warranted according to CSR 34-325-118 parent 3 parent A, and issue an order directing the affected financial warrantors to immediately deliver to the board all amounts warranted by the applicable financial warranties in accordance with CSR 32-30. Speaking will come tomorrow. CSR 34-32.5-118 parent 3 parent B, and to waive the remainder of the civil penalty of $38,700 that was due and payable.
Is it friendly? Do we need to mention the reason we're waiving that is because of the insolvency of the permittee?
You don't
Then we
have
need to
to.
verify that, wouldn't we?
Yeah,
Chuck, we don't need that?
you don't have to. It's up to the board. I think you've got just,
Okay.
you're
think it
fine.
makes
Jill, I second your motion.
Okay. Motion on the table as written, and we have a second. Any further discussion? Hearing none. All those in favor, say aye.
Aye.
Those opposed? Motion passes. Thank you all. Yeah, just a unique situation, but I think this makes it much cleaner and clear for a path forward. So thank you all for delivering that information for us. All right.
If I could, just before I leave, I wanted to, because I know we don't always hear the good things. I thought Ms. Michaels was very professional in dealing with this situation, which I'm sure was unique to everyone and unique to her. And I appreciated her correspondence and her work with my office so that we could understand a unique situation that we haven't dealt with before as well. So I just wanted to say that before I left.
Thank you, Ms. Oyen. I appreciate that.
Thank
Kudos
you.
to staff. And Ms. Michaels especially. All right, next up, item number 6, another enforcement hearing for file number M-1985-203, Joseph Welt and Summit Brick and Tile Company. All those providing testimony, will you raise your right hand? You promise to tell the whole truth?
Yes.
Great, thank you. And Ms. Michaels, you're up again.
Oh, wrong side though. How can you do that? Oh, this one. Oh. Right. Hi again, Amber Michaels, and I'll be representing the division. This hearing is for the Edmondson Clay Mine, permit number M-1985-203. This is permitted and operated by Summit Brick and Tile Company. This enforcement hearing is for the consideration of a possible violation, cease and desist order, corrective actions and civil penalties, permit revocation and finding the financial warranty subject to forfeiture for failure to first obtain from the board or office a reclamation permit prior to engaging in a new operation for affecting more than 2 acres outside of the existing permit boundary, and or failure to protect areas outside of the affected land from slides or damages occurring during the mining operation. This site is located in Pueblo County, and it's approximately 24 miles south of Pueblo, Colorado. This is a 110 limited impact construction materials permitted for 9.8 acres. The mining commodity at the site is clay, and the post-mine land use is rangeland. The existing bond held by the division is $19,350, and the division has determined this is adequate at this time. The mining plan originally submitted with the 110 application is the currently approved plan. There have been no revisions to the map or to the boundaries since the permit was permitted. However, there are some issues with the permit and the approved map, or with the approved map. The map submitted with the application is spatially inaccurate and has an area greater than what's possible for a 110C permit. The site was approved to affect 9.8 acres, but the boundary on the map encompasses an area that's approximately 12.91 acres. So therefore, the approved map does not match the approved acreage, the mining on site, or the markers placed in the field. In May, the division conducted a routine monitoring inspection. And during the inspection, the division located two corner boundary marker posts. And those are indicated by these red dots on this image. The division also determined the northernmost and the southernmost extent of the disturbance on site. And that's indicated by these white slashed circles. This orange polygon represents the approximate location of the perma boundary in reference to the marked boundary markers and the approved permitted acreage. So when we look in respect to that orange boundary, we notice that these areas in red indicate disturbance that occurred off-site. But after talking with the operator, it sounds like this area to the west where a road has been constructed was actually constructed by an electrical company. So the division has removed that from the total affected acreage outside. So if we look at how mining has progressed through time and through the life of this mine, the first clear image that we see in Google Earth is a September 1999 image. And that shows mining began north of where the permit is, where the permit boundary is, and progressed towards the south. And then October of 2015, we see mining continued southward, but at that point, it progressed past what's marked in the field as the southern boundary. And then in 2020, reclamation efforts brought that disturbance to its current southernmost extent. In 2023, the annual report map that was submitted seemingly shifted the boundary southward of what was being reported on all the other past annual report maps, which had edited the original approved map as their submissions. And although the disturbance inside the square, inside the permit boundary that was indicated on this map matches what's on the ground, everything that was reported as mining disturbance on prior annual maps was omitted, as well as everything that occurred to the south. After removing the road constructed to the west, the division determined that the total affected acreage off-site is 2.95 acres. The area to the southwest that was most recently mined and most recently reclaimed is still undergoing reclamation, but it's not releasable at this time because the vegetative cover is not adequate, it's not established. As you can see in these pictures, a lot of it is annual weeds, such as some Russian thistle that you see in some of these images, and there are some bare areas throughout. So the division conducted a routine monitoring inspection on May 16th, 2023, determined that the affected acreage off-site is 2.95 acres, and that this acreage included a partially reclaimed area to the south and reclaimed areas in the north. Then on July 17th, 2023, the division sent the operator a reason to believe a violation exists and notice of board hearing letter. This was received by the permittee on July 19th of 2023. The division believes that the reason for the violation is that 2.95 acres have been affected outside of the boundary, and that the affected acres meet the definition of affected land pursuant to the statute and the rule, and that the affected land meets the definition of being part of a mining operation pursuant to the statute and the rule. Therefore, in accordance with the statute An operator who mines substantial acreage beyond the approved permit boundary may be found to be operating without a permit. And the statute states that an operator must obtain a reclamation permit from the board or office prior to engaging in a new operation. And also pursuant to the statute, areas outside of the affected land shall be protected from slides or damage occurring during the mining operation and reclamation. The division recommends that the board find the operator in violation for failure to obtain a reclamation permit prior to engaging in a new operation pursuant to CRS 34-32.5-109, parent 1. The division also recommends that within 90 days of the effective date of the board's order, the permittee shall submit either a conversion application or an amendment application to encompass all the affected land at the site and obtain approval of the required revision within statutory deadlines. The division recommends that the board issue a cease and desist order, and the statute states that the board may issue a cease and desist order prohibiting any further mining activities except those activities approved by the division in writing as necessary to comply with the conditions of the order, prevent damage to offsite areas, or to protect public health and safety until corrective actions have been resolved to the satisfaction of the division. The staff recommends that the board assess civil penalties pursuant to the statute that state the minimum amount would be 1,000 per day and the maximum would be 5,000 per day. The statute states that the board shall assess a civil penalty and the amount necessary to cover costs incurred by the division in investigating the alleged violation. This equates to 5 hours of staff time at $56.64 per hour. And the division believes that the operator has been in violation for 30 days, starting on July 17th, 2023, when the RTB was issued, and to today, August 16th, 2023, at the board hearing. The division recommends that the board assess a civil penalty of $30,000 and that they suspend all but $4,783.20. This being $4,500 of civil penalty plus $283.20 of staff time if the operator complies with the corrective action. This brings the total penalty to $30,000. The total penalty to be suspended at $25,216.80. And then the total unsuspended penalty to $4,783.20. Questions?
Any questions for staff?
Mr. Chair, Tim Mock. Ms. Michaels, going back, it seemed to indicate that we realized that there's some violations in the past in terms of going outside the permit boundary. Were those addressed back then at those times? How was that kind of factored into this?
No, because at the time it wasn't realized that we were outside of, or that they had gone outside of the boundary. How it had been reported on past maps was that they were inside, and there seems to be a discrepancy of where the boundary markers were throughout the life of the permit, but we couldn't find exactly if or when they shifted, or if we just missed it.
Thank you.
Any more questions at this time? All right, well, I guess we could hear from the operator now. If you have anything to add.
So basically, we do not deny that we are out of bounds. We are in agreement with that. My understanding is that the markers in the boundary were placed in 1985 with a tape and a compass and have not really changed since then, to the best of our knowledge. As you can tell, this is a pretty remote site, and so there's also cows on the land, and the landowner does allow hunters as well. So, but to the best of our knowledge, the markers have never moved. And we are willing to do the corrective actions necessary to bring this under compliance and finish our reclamation.
I think I would add to that this site's mining is complete at this site. They've decided to reclaim it. And there's about 4 acres, I would guess, maybe a little more, and Amber can qualify that better, of area that just needs remedial seeding on it. And so that technically the site has been reclaimed. My past experience at the mine is these boundary markers and fence posts out there that mark the corners from 1985. They're all over the place out there. And so, you know, not to make excuses, but it was unclear what the original permit boundaries were on the ground, I believe. Part of the evidence that there was some confusion is the original vicinity map showed that area being a block higher or north of where the actual boundary was supposed to be. And so there's been confusion throughout this thing, but that's no excuse. We believe that doing an amendment to the 110 as a reclamation only would be the appropriate way to handle it, probably the most expedient way to handle it. And basically means revising the maps, updating some of the areas within that permit and getting it filed and turned around. So I think that's where Summit is prepared to go with it, assuming staff is in agreement with us on it and everything, if that's the way to go.
Can I ask a question?
Yeah, go ahead, John.
I guess I'm having trouble exactly locating where it is. I'm just out of curiosity. And how do you access it? I mean, I kind of know that country out there.
So we actually access it. Oh, I can't think of the highway.
You go down to Walsenburg and
Yeah.
go east out of
Or you go come back
Walsenburg.
on Highway 10?
Yes, correct. And then,
You turn up the Red Top Road or?
yeah, I think it's actually about 13, I can't remember the exact number. It's either 13 or 18 miles off that road that we have to go in order to get to this particular mine.
North of it.
Yeah, north.
But is it inside the Butler or the Edmondson?
It used to be, my understanding is it used to be owned by Edmondson, and then they sold it to another, like they parceled their land and sold it. So it's no longer owned by Edmondson. It was in the beginning, but it is no longer.
Doesn't Red Creek Ranch own some to the east or west of it in there?
Yeah, I believe so.
Yeah, Betsy Meacham owns a piece to the west of it, Pine Valley.
Yeah. Yeah, the Butler or Hermosia now, I guess it's called.
Yeah.
So what you're saying is what you'd like to do is just go ahead and reclaim it and get out of it, right?
Correct. It's all the hopefully Amber can confirm this, but the grading and earthwork is already completely done. It's just getting the vegetation to establish.
On the southern area, right? Not the whole thing, just. the
Correct,
southern-
yeah.
just section of southern.
Just the southern area and a little bit to the west, where the topsoil pile is. We need to get the vegetation there to take as well. We also have, there's a couple things of refuse that we also need to get off of the property. I believe the pipes that are there are actually owned by the landowner. I will have to confirm with him. There is a fuel truck though that was owned by our mining contractor who is now, he sold his business. So we would either need to contact him to take the fuel truck off the site, or we will have to get it off the site ourselves.
Great. Thank you, Mr. Walt and Ms. Walt. Yeah, go ahead.
Gary, yeah, just one point of clarification, kind of to speak to what Steve was talking about in terms of the corrective action. The way we worded the corrective action gives the operator some flexibility, whether a conversion application to a 112 is necessary or a 110 amendment is also possible. What we do caution and recommend is that they get a surveyor out there to get the exact acreage, because the 110 does limit them to less than 10 acres. And the affected land out there is pretty close to that based on our estimation. So if there's any additional land that could possibly be affected by, continued reclamation work, they may want to give themselves a little bit of room and just go ahead and do a 112 conversion. But we'll leave it to the operator to decide kind of which path they want to go. They're recognizing that they may need some additional room. So that'd be my one point of caution there.
Thanks, Mr. Ebert. Would that be amenable to you all, Mr. Biswell? Just going for the 112 instead of the 110 conversion?
I think our preference would be the 110. However, if we get like an actual acreage on it, and realize that it's not possible to do a 110 within the current regulations, then we would do a 112.
Okay. So it sounds like we just need to get it surveyed and get an actual measurement of the property. That's kind of the first step here. All right. Any more questions or comments at this time? If not, I guess we could entertain a motion.
Mr. Chair, I'll give it a whirl here.
Okay.
I move the board finds the operating violation pursuant to CRS 34-32.5-109 parent 1 for failure to obtain a reclamation permit prior to engaging in a new operation. That we issue a cease and desist order prohibiting any further mining activities except those activities approved by the division in writing as necessary to comply with the conditions of the order, prevent damage to offsite areas, or to protect public health and safety until corrective actions have been resolved to the satisfaction of the division. And then within 90 days of the effective date of the board's order, the permittee shall submit either a conversion application or an amendment application to encompass all of the affected lands on the site and obtain approval of the required revision within statutory deadlines. And that the board, that the division that the board assess a total civil penalty of $30,000 with all but $4,783.20 suspended if the corrective action cited above are completed to the satisfaction of the division within the required deadlines.
Mr. Mock, would you entertain a friendly amendment?
Maybe, depends on how friendly it is.
It's pretty friendly. Because of the reputation of this company and what it does in Southern Colorado, I would recommend we make that fee instead of $4,000 something $500 if they do what they say they're going to do.
That has no objections.
Okay, yeah, so I'm sorry, Mr. Singletary, I think I missed you there. You're waiving the civil penalty?
Waiving all but $500 of it.
Waiving all but $500.
Yeah.
And staff time.
And is a friendly amendment to your friendly amendment. Can we include the staff time there? The 280?
Yes, please do. Right.
So it would be $783.20. That would be not suspended. Yes, so that's my motion, and I would agree with Mr. Singletary. To the operators, do appreciate your cooperation and collaboration, working with staff on this and taking the time to join us today. So thank you very much. It does mean a lot.
I'll second that motion.
All right, we have a motion and a second. Any further discussion?
I have a question of the operator.
Go ahead,
This
Joe.
this gives you 90 days. Do you intend to get the surveying done and if needed, come in with that amended plan in 90 days?
Yes, we do not anticipate any issues, especially if we can actually go forward with the 110 amendment. The 112, I think we would also be able to, especially with a lot of the groundwork that Amber has done. We can actually build pretty quickly off of the aerial images that she provided in her inspection report. Do you agree with that?
I agree with it.
Yeah.
Yeah, it's a reclamation only permit even if we go to a 112, so it's not like we've got to design a big reclamation permit, you know, to handle it. So it's mostly mapping work,
Yeah, mapping and then the just a little bit of narrative.
notices, things like that.
Yeah.
So should be easy.
All right, I just know 90 days can go really quickly.
Yes.
Yeah.
Thank
All
you.
Yeah, thank you, Ms. Nelson. I guess we'll just go ahead and vote. All in, or anybody else? Okay. All in favor, say aye.
Aye.
Those opposed? Hearing none, motion passes. And yeah, thank you for everyone for sharing information and getting a good resolution here. Thank you, Mr. and Ms. Welt, for joining us today.
I would second your previous case representative saying that Amber's been a pleasure to work with. Very professional. She's answered questions, returned calls. I've really enjoyed working with her so far and look forward to it in the future.
Yeah, I would second that as well.
Everyone's made it easy for me.
Great. Thank you all. Enjoy the rest of your day.
Thank you.
Thank you.
Ms. Michaels, we'll have to give you the full agenda next time too.
Yeah.
Yeah, right? That's what you get.
Guessing it's a bigger one, huh? All right. All right. Well, thanks everyone. Do we have education staff information today?
Mr. Chair, this is Russ Means for the division. We did not line up any entertainment for today, so we will pass on that. Thank you.
All right. And is there any public comment today?
Not today.
Okay. All right. Well, I'll go ahead and make a motion to adjourn.
So moved. There's second.
All right. We got plenty of seconds. All those in favor?
Aye.
Aye.
All right. Motion passes. We'll see you next month. And if it's longer, hopefully in person, you know, so let me know.
Isn't it funny?
Yeah.
All right.
Right.
Thank you all.
Thank
Have
you.
a good rest of your day. Take care.